Hey, good morning, everybody. It's Law and Legitimacy, and I have been properly admonished in the pre-broadcast moments. Sit near the microphone. Don't sit back. Keep your hands on the wheel and your eyes upon the road. It's Thursday, the day after Hump Day, and we're looking at Georgia, and we're having WTF moments. And
10 and 2, Norm. Keep it 10 and 2. We got to keep it 10 and 2.
10 and 2. What did I say?
No, you didn't say anything. I was just making sure. Just 10 and 2 right here.
You heard it all there, folks. He didn't say it at the end of the show. He said at the beginning. You didn't say anything. But look at what's going on. Okay, so it wasn't Fani's fault. It wasn't Fani's fault in Georgia that the jury pool was tainted by the broadcast of proffer sessions. That is, recorded sessions privately with, among others, Jenna Ellis, Sidney Powell, Kenneth Cheeseburger, and Scott Hall.
Cheeseburger.
It wasn't Fani's fault that these things were publicized. No, she wouldn't do that. She wouldn't taint the jury pool. She wouldn't produce information that was so prejudicial to the defense. She wouldn't undermine the defendant's fair trial rights. She's an officer of the court. She knows better. No, Fani didn't do it. So who did? Well, the American Bar Association's award for creative lawyering this week goes to Georgia's Jonathan Miller. He's representing Misty Hampton. I mean, you can't make this stuff up. I mean, we've got Kenneth Cheeseburger, Misty Hampton, Donald Trump. The cast of Fat Fani Willis. I mean, is this going to be a trial or is it going to be a live Saturday Night Live broadcast? Jonathan Miller, lawyer for Misty Hampton, he acknowledges that he released the videos to at least one outlet. Jonathan, what were you thinking? I mean, everybody wants their 15 minutes of fame. I get it. I mean, I have been known to run my mouth, sometimes inappropriately, in the presence of cameras and in high-profile cases. And why? Because it's fun. But I try while doing so to serve my client's interest. What possible justification could Jonathan Miller have for releasing these videotapes other than, what possible justification? He wasn't even part of the publicity.
Here's the quote. I'll read it for you. Quote, "In being transparent with the court and to make sure."
In other words, just so you can see what a complete ass I am. Go ahead.
You're right. And to make sure that nobody else gets blamed for what happened.
In other words, I don't want anybody else to be thought of as a half-wit, unethical moron with no regard for the rules of professional conduct or the fair trial rights of those accused. Please.
This is just him throwing himself on the mercy of the court before he even drops the bomb. He's like, I'm really a decent guy. I promise. And so that I can go to sleep well tonight, Judge. I did release
a dirt nap, Johnny, baby.
I did release those videos to one outlet. In all candor to the court, I need the court to know that. Asked why he'd done so, he noted that while the 4 guilty pleas were public, quote, to hide those proffers that show all the underlying things went into those pleas, it misleads the public about what's going on. I'm not even sure I understand.
Well, look, I mean, I do understand the Miller's point with respect to the unseemly character of plea bargaining. I think Bismarck once said that legislation is like, sausage. You don't want to know what goes into it. Plea bargaining is ugly. We've talked about the dark side of plea bargaining, the inducements that are brought to it and so forth. But here's the fact, Jonathan. Did you really think that by releasing these videos, the press would do anything other than cherry pick and take out the juiciest moments? Or as we saw, and I believe it was ABC, that they wouldn't snip pieces together to make it sound as inculpatory as possible. So, Jonathan, he makes a public plea for transparency. He says it's vital in this case. This case is about core threats to democracy and legitimacy and all that other jazz. And of course, he's right. But the method in which he did this was altogether wrong.
Norm, is this something that you would ever indulge? I'm trying to think of just the notion that defense counsel in a case like this would just simply release videos to the media of like proffer videos that were made pursuant to plea deals for witnesses that will be cross-examined in the case. I mean, it's a kind of a wild decision to make, in my opinion. I mean, and I'm not a criminal defense attorney by any stretch of the imagination. However, just on a basic sort of the fact that this is news, the fact that this happened, is just interesting to me. Are there any other examples of this being done, or is there some sort of protocol around this stuff, Norm?
Well, let's talk about the ethical contours within which these moves were made. It'll come as a surprise to some viewers and listeners that lawyers operate under refined ethical rules. They're called the rules of professional conduct. And so the cardinal rules for all lawyers are candor toward the tribunal, that is, not knowingly misleading the court, being truthful to the court about both facts and the law, such that if you're arguing a legal proposition that you're entitled to relief of some form, and you are aware of a case that says you can't have it, you've got to let the court know about that case. You can't pretend, well, you're the court, you know everything. So there's a duty of candor toward the tribunal. There's a duty of zealous advocacy toward your client. Or when you represent a client, you represent that client to the exclusion of the world. And your sole duty is to that client. And your duty is to be a zealous advocate, to do everything that the law permits you to do on behalf of that client's interests. And then you have a duty to communicate with the client to determine what he or she regards as his interest. The classic and paramount interest in a criminal case is obviously a liberty interest. Oh, get that photograph off the film. We're not doing a Fat Farm advertisement here.
This is the defendant in question here, and I just wanted to kind of give everybody a sense of who Misty Hampton is. She is the former Coffee County Elections Director, and she is charged with 7 counts in this case: 2 of conspiracy to commit election fraud, 1 violation of the Georgia RICO Act, etc.
Buy a Peloton, babe. Drive by Chuck E. Cheese, okay?
Yep.
You don't need to stop every time.
Add me on Peloton too. I'll show you the way. Power zone training, baby.
So, those are the obligations of lawyers on both sides of the aisle, both with respect to the criminal defense and with respect to prosecution. Prosecutors have an extra duty. They have a duty to do justice, or to see that justice is done. And it's easy to ridicule that. Defense lawyers don't have a duty to do justice. Their job is to do what the law permits them to do in their client's interest, in particular in their liberty interest. And so this takes us to evaluating Jonathan Miller's conduct. There aren't bright line rules in general about what you can and cannot do. You have broad strategic discretion to do what you can to disrupt the state's case. That is a legitimate goal for a criminal defense lawyer. But one of the things you can't do is engage in prejudicial, extrajudicial, out-of-court statements that are likely to prejudice an adjudicatory proceeding. And so broadcasting material that undermines the defense case months before jury selection is to begin in a high-profile case is arguably improper in any case. And so I think Jonathan Miller has exposed himself to charges that he breached his ethical obligations to the court. And it wouldn't surprise me to see disciplinary proceedings launched against him.
So in addition to that, what came to me immediately after thinking of the ethical quandary that he'll find himself in very short order, if he has not already, is what the pleading parties might pursue against him in a civil context. Is there, based on what's happened here, I mean, Jenna Ellis's name has been dragged through the mud. Now, there's a lot that she's done on her own to find herself in that position, but is there any sort of, you see there's potential for civil consequences aimed at some sort of defamation, et cetera?
It wouldn't be defamation, but it could be breach of privacy by publication of private facts. That is a tort that most states recognize. It wouldn't be defamation because she truthfully said these things.
And what about ABC, for example, chopping and splicing up the video in a very certain way?
So I still have enough confidence in the legacy media that I don't think they made yes appear to be no. I think what they probably did was chopped out some of the non-fluencies and intervening chatter that goes on in a proffer to get to the point. But you'd have to compare the raw video versus the video that was published. If ABC altered the content such that it made yes appear to be no, or it made her appear to say things which she never said, then of course ABC will have liability.
Just parting shot here. Liberty Warrior over on Rumble says, of course they have to start the article with Trump's name to tie it all to him. They could have left that part out and just said say, an attorney for said defendant. And I agree. I was looking at this stuff this morning, kind of searching for various articles, opened up The Independent, opened up NBC News and several others. And it is, I think that's in large part due to the SEO optimization for these media outlets, putting Trump's name in the title. I mean, we've done it here, so I can't, we're not exactly clean hands here in terms of putting Trump's name in a title. However, I do think that the nature and character of what's happened here, the ethical issues, are definitely being tied to Trump's name, even though it has nothing to do with Trump or his defense counsel.
No, and I think that it compounds the harm, candidly, because what you've got is yet another reference to Scavino, basically saying, a senior White House official in December of 2020, we don't really care about the legalities. We're not leaving. Every time that is broadcast or repeated, it compounds the harm. We just compounded the harm. That's I guess that's what makes the case newsworthy.
We've done more to clarify who Misty Hampton is than anybody else I've seen report on this. So there you go.
All right. But as to Jonathan Miller, if I'm Misty Hampton, I would candidly be questioning my choice of counsel right now. And I think the court does need to inquire what sort of strategic rationale was Jonathan Miller serving. He doesn't represent the public at large. However important transparency may be in this case, while as an officer of the court, it's not his job to serve the public interest. It's his job to serve his client's interest. And it's hard for me to see how broadcasting these videos serves Misty Hampton's interests. So, and I apologize to Misty. I shouldn't have made fun of your girth, but that's one of my many failings. So here let's pivot to Trump's claim for a mistrial in the Manhattan civil fraud case. The Trump team has moved for a mistrial, claiming that Arthur Engoron, the judge, and his co-counsel, his co-judge, non-judge Allison Greenfield, who sits on the bench with him and whispers notes to him and passes in notes while he presides over court. The Trump team has declared and moved for a mistrial, saying that there is bias by the judge and his, quote, inappropriate law clerk. Mistrial motions are not often granted, especially in what are known as court trials. If you have a dispute with another party in civil court, or even in a criminal court, you have a choice. You can have a jury or not. Now, in the Trump case, apparently his lawyers never moved to have this heard by a jury. And you saw this early in the civil fraud trial in Manhattan, where Engoron basically said, nobody asked for a jury trial, so you're getting a court trial. Judges are presumed to follow the law. The law is steeped in presumptions. These are what are known as rebuttable presumptions. They are assumed to be the case. They are assumed to be true unless someone can prove otherwise. So there is a rebuttable presumption that judges follow the law. It's not like a jury trial where small things that could influence a jury could yield major harm. And so one of the reasons you don't choose a court trial is you lose appellate leverage. There's going to be a lot that happens in a trial, especially a hotly contested, high profile trial. And if you want to make the most out of every error that a judge might make, you want a jury where you can say to the appellate court, look, the judge screwed this up. It misled the jury. In this case, the claim will be that Engoron's defense, or the state of New York's defense, when it defends this mistrial motion denial, which it will be denied. You heard it here first. On appeal, there's just not going to be much traction. The court will say, well, isn't the judge presumed to follow the law? Can you point to an area in which he didn't follow the law? And here's the area that I would find most promising, were I on the Trump team. What is Allison Greenfield doing sitting on the bench with the judge? Donald Trump didn't choose this fight. The people of the state of New York brought it through the Attorney General's office. And if Trump chose not to have a jury trial, if he didn't file a jury claim, then constructively, meaning he by operation of law, he chose to have a court trial. In choosing a court trial, he chose to have the case decided by a judge, not the judge and his flunky, sitting next to him. And you see here on a photograph, the judge is turning to her with some sort of look, and she's got a smirk on her face, sort of like saying, I've got their number. Who cares about her? She wasn't appointed by a governor. She wasn't vetted by the legislature. She doesn't serve at the pleasure of the people of New York. She's one of the court's employees. And so it seems to me that Trump has a claim. And it seems to me that there should be an inquiry as to the relationship between Engoron and Greenfield. And it should go along the following lines. Judge, what were you thinking when you issued a gag order against Trump to protect him from picking on your law clerk? Who cares about your law clerk, whether she's discomfited by this or not? And Judge, having taken these extraordinary steps to inhibit the former president's and his team's right to speak, why in the world are you sharing your bench with her, sir? And Judge, if you're on the stand in my court, what are you talking to her about in the middle of evidence? And have you preserved the notes that you were sending back and forth? Judge, do you feel incapable of presiding over your own courtroom such that you need the help of someone whose tender feelings you regard so highly, and you need a tutorial from a law clerk to help you preside over a trial? Judge Engoron, if you don't feel up to the job, why are you doing it? I cannot think of a case that I've had, and I've had thousands of them at this point over the last 3 decades, where a law clerk sat on the bench with the judge at trial so that they could engage in a collegial and communal sort of communication about the case pending before them. It's just unheard of. And so in terms of undermining public confidence in the courtroom, it seems to me that a powerful argument for the Trump team to make is that we had, in effect, a judge that came up through the normal process, the appointed process, deciding a case with a representative of what? The deep state? The civil service system of the city or the state of New York? He didn't, Judge, ever seek, Mr. Trump didn't, that is, a co-trial between a judge and his semi-professional clerk. So I think it's a bad look. I still don't think it's enough to get a mistrial, but it's a bad look.
Yeah, so we've got several questions. I'll point out that not having a jury for this is perhaps a strategic error in hindsight, simply because what I do think that Trump's legal team is doing extraordinarily well here is making this an issue, pointing out something that is a clear vulnerability for the court.
Mm-hmm.
But what's not happening is that that's not being done in front of a jury, right?
True.
That repeated reference, that just the making it an issue in front of the, in front of the triers of fact is something that Trump is now being deprived. We do have, like I said, several questions here. Maury asks, don't you have to raise the issue in the first trial in order to raise the issue on review?
Yes, and I think by raising the mistrial motion, they are in part highlighting that. I don't know, Maury, I haven't followed the trial closely enough to know whether they've objected to her presence and participation. They should have. And if they didn't, that would be another example of being somewhat asleep at the switch.
Dawn asks, why did Trump/lawyers request a court trial and then complain about no jury trial? Confusing.
Yeah, it seems to me that this is an example of lawyers potentially being asleep at the switch. You have to claim a jury trial, usually by way of claim. What does that mean? You have to ask for a jury trial in your pleadings in almost every jurisdiction. Now, I'm not admitted to practice in the state court system in New York, only the federal courts. But I know in most state court systems, if you are looking for a jury, you have to ask for a jury trial at some point early in the process so that everybody's on notice. It appears that the Trump team didn't do that. And by not doing it, they waived the right to complain about it later. So why did the Trump lawyers request a court trial, then complain about no jury trial? I think they forgot to ask about a jury trial, got caught with their pants down, and then tried to blame the other guy. I think it's sloppy lawyering on Team Trump.
Indeed. Okay, well, let's move on. I agree with you. I don't know that there's any prospect that this motion for a mistrial is going to be granted.
So is it really better to rule in hell than serve on bended knee? That was Satan's position in Paradise Lost. And, I talked about that book a lot with folks because people say, how can you defend, the people you defend? Well, I mean, of course, knowing what I know about the criminal justice system in the world at large, I always turn the question on them. How could you not? I mean, the savagery that we call justice and the charade that goes on in court that we call fairness, the consequences that we call punishment and rehabilitation, decades in prison. How would you not rise to the challenge of standing with someone and defending them against the behemoth? To me, that's a no-brainer. I mean, the real question is, how could anybody in their right mind make a decision to be a prosecutor? I mean, there's a reason why Jack Smith, special counsel against Donald Trump, every time you see a picture of him, he looks like this. Like he swallowed a jalapeno pepper. Hi, I'm Jack Smith. I'm shocked by it all. I mean, if that guy's not on the spec, yeah, look there, do your Jack. I mean, one of my grandkids wanted to be Jack Smith for Halloween. We said, no, it's just too scary. I mean, and there has to be some limits. Well, in any case, Satan is a wonderful figure in Paradise Lost in many regards because he knows he's a subaltern. He's one of the angels serving God Almighty. And he has to know that he can't win in a rebellion against God, but he rebels nonetheless. He rebels in Paradise Lost, and there are some classic lines in the poem that talk about the reasons for his rebellion, and among them is that it is better to reign in hell than to serve on bended knee in heaven. And that works in a way. It works in a way in the sense that we all crave significance, that we all want to chart our own course. But as we've said before, probably already this week, sin is love of the wrong thing. And Satan exemplifies the sin of pride, the sin of wanting to remake the world in his own image and not recognizing the authority of God. So Satan in Paradise Lost is a sort of classic rebel without a cause. He's the person who revels in rebellion for rebellion's sake. And of course, it brings down destruction on his head. But yet, we are all anti-authoritarians in the United States, and that is perhaps a good thing. So, in the small town of Lebanon, Connecticut, there's going to be a Bible club. Elementary students are going to be permitted to read the Word of God because, after all, there is something significant about the Bible in our culture and in our history. And if children want to engage in some reading of it and application of its teachings to their own life, that's a choice they can make. As long as the state isn't requiring it, it doesn't violate the First Amendment's Establishment Clause that prohibits Congress or a public entity from establishing religion in the United States. And it does serve the Free Exercise Clause because it makes available public space to individuals who want to use it for their own purposes. So in comes the Satanic Temple. The Satanic Temple says, well, okay, if the state can't establish religion by requiring people go to Bible club, but it can promote the free exercise by making public facilities available to Bible reading children. What about the Satanic Club? Can't we have a worship or reverence or regard for Satan in the classrooms under the Free Exercise Clause? And so they've gone to Lebanon and petitioned for the right to have a Satan Club in the school as well. On First Amendment grounds, I think formally they're correct. If there's going to be a Bible club, there can and should be a Satan Club. But who in their right mind is going to send their kids to a Satan Club? Now, the founder of the organization is interviewed at length in a piece in the Connecticut papers, and she embraces Paradise Lost, and she embraces the figure of Satan in Milton's portrayal of him, and says, that Satan in Christian theology is actually an evil person and is the source of our undoing and our misdirected drives of love and of original sin. But yet there is a role he plays in our tradition where he challenges authority. And he stands for the little guy. He stands for the LGBTQ community. Hi, I'm the devil. You can march. I'm the devil. For a limited time only, you can munch on my sulfur-infused carpets for $69.99. But buy now, pray later. He becomes a figure of defiance against constituted order. He becomes the central point of seeking diversity for diversity's sake. He becomes the god of self-expression. And, in that way, the Satanic Temple holds in relief the crisis, the spiritual crisis of Western civilization right now. I have to agree with everything they say. I have to agree that on First Amendment grounds, they have a right to be present in the school. I agree and appreciate Satan's role in literature, in particular in Paradise Lost. And I am the first one to stick my eye in the finger of authority and say, gotcha. Or I will represent my person in defiance of the mob, because, as I said just yesterday, there is no mob quite so self-righteous or scary as a self-righteous mob. But yet, I have to wonder whether educating with Satan, after school Satan, is really something we want to be doing in our schools. Because while we want to say that we value individuals and we respect the choices that individuals make, don't we do so against the assumption that in the end there are some choices that are better than others? Or do we want to say to elementary school children that every choice is sacrosanct because you've chosen it? And is that a message you want to send to a third grader and a fourth grader, that we're going to, in effect, deify your choice because you made it? I thought the purpose of education was to form character. I thought the purpose of a public education was to prepare people for the obligations of citizenship. I thought that the purpose of a general education was to create a better society, a society in which we can all live with common conceptions of right and the ability to have settled expectations that we won't get killed when we go to the grocery store for a jug of milk. Is teaching a child that every appetite is right because it's theirs part of a public education? And if it's not, how do you square that with the First Amendment? And I don't know that it can be. So this is a case, Mike, that confounds me, because I don't think that Satan clubs have any role in a private or in an elementary school education. But yet I don't know that the First Amendment can prohibit their exclusion. And so I find myself wrestling in a way with an echo of the debate you and I have on a running basis about whether to limit kids' exposure to TikTok, because at some level they are young and impressionable, and we expose them to an environment that really isn't good for them and isn't therefore good for us. I'm not sure that educating with Satan in the elementary school is anything other than a watered down version of transvestite story hour. And I don't know that I approve of that. I don't know that I think it makes sense in a good society. And if the solution is then going to be, well, we're not going to have after school enrichment clubs that bring perspectives on the world at all. In other words, we're going to preclude schools from having Bible clubs. We're going to preclude them from having Satan clubs. It still seems to me that in the end, society is a net loser, because the Bible does bring enduring values and is a foundation of our culture and of our civilization. And the Bible's portrayal of Satan captures a reality that individuals left to their own devices become prisoners in a hell of their own creation. And they can say with Satan, better to reign in hell than serve in heaven. But I'm not sure we want to be training or teaching children about the benefits of hell. I'm simply confused on this issue, Mike, and I don't know where to turn.
Yeah. The reason I brought what's on the screen is to introduce exactly what the, I guess, supporters of the After School Satan Club would say in response to you. It says here, the After School Satan Club does not believe in introducing religion into public schools and will only open a club if other religious groups are operating on campus. So first and foremost, that is that establishment clause challenge, ultimately. The strategy and the positioning of the After School Satan Club is indeed designed to drum up a lawsuit from some unwitting public school district where the administration would rightly listen to the parents, right, of the elementary school aged children that they are responsible for, and perhaps excluding After School Satan Club from being on campus. But as we know, the First Amendment prohibits the state from promoting the establishment of religion. right? And so this is a classic case of, if you allow the free exercise of religion on a public school ground, right, after hours, etc., to the benefit of one particular group, and then subsequently exclude another group based on the same criteria, or criteria that is grounded in that religious belief, there will be a lawsuit. It's a viable lawsuit, a First Amendment lawsuit. So I have a problem with the positioning of this program from the outset. They say that they will not go anywhere where there is not already a sort of pro God or a pro Christian group doing something. So in other words, they don't go anywhere there isn't already some affinity for the Bible, right? Which, you start there. But then we look at what they actually say about, and how cynical of a position they say. Unlike our counterparts who publicly measure their success in young children's, quote, professions of faith, the After School Satan Club program focuses on science, critical thinking, creative arts, and good works for the community. That sounds like every liberal yard sign I've read for the last 3 or 4 years, right?
It really does.
You know, we believe in science, kind of thing, right?
You know, this is we haven't talked about the concept of the bottom falling out of pluralism in a long time, and this illustrates exactly what's at stake in the cultural wars. You know, pluralism. Isaiah Berlin once wrote a classic essay, "The Hedgehog and the Fox," and it was a contrast between two philosophic orientations to the world: monism and pluralism. Monism was the idea, that was the hedgehog's perspective. There was one great.
Move a little closer to the mic, please, Norm.
Yes, sir. My seatbelt is on. Keep your eyes upon the road. Hands are 10 and 2. Don't sit back. Swallow the mic. I go down. Okay, I'm there, but everybody. I swallowed. You know, but I mean, the notion of a monist was that there was one great truth that explained the world. You know, a God intoxicated man, to use that trope from literature. The fox, on the other hand, believed there were many truths. Was a pluralist, and so in terms of living the good life, or how to live a good life, a monist would say there's one way to do it. A pluralist would say there was many. In the liberal democratic tradition, we've engaged an ethos of pluralism, and we've said that there are many ways to the good life. But we've agreed that there was such a thing as a good life, and we could have a meaningful debate about it. When we talk here about the bottom falling out of pluralism, what we mean is that we've lost any conception that it made sense to argue about what a good life is, that somehow values are ascribed to the act of choosing rather than debating whether the object chosen is worthy of choice at all. And so the bottom falling out of pluralism means a sort of cynical disregard for the value of things and a decision to choose things simply because they can be chosen. And the result is we end up with people without conceptions of the good life. We leave them on their own, untethered to a community, untethered to resources, untethered even to their families. And we say, hey, you know, just choose, because whatever choice you make will endorse and will come to your rescue. You just can't have a good society that way. If you're chasing after every whim as though it were of social value, you're wasting resources. Classic example: transgender surgeries for kids. This is just ridiculous. And I think there will be a backlash, if not in 2024, shortly thereafter, by people who have 2 feet on the ground and are saying, wait a minute, it's not good simply because it's chosen. It's good because the object that it chooses has some value, has some social utility. And so the Satan Club, in my view, is a derivative organization. Dawn refers to them as basically trolls. I think she's right. They're trolling on the Christian tradition and claiming that Satan's independent, but they only want Satan to eat where Christians have set the table. And I think that they're sort of the merry pranksters of our time.
I'm not touching you. I'm not touching you. I'm not touching you, ass boy. You guys suck. You suck. Yeah. You just suck. They're like, we're atheists. We're not religious. You just suck. I don't care. You just suck. The good news.
Having said that, you know, they've got the protection of the First Amendment, and so this is in the class of those discussions that we have about things like hate speech. At what point do we have to rethink the ethos of defending all expression because it's free? because we value freedom of expression? Or do we reach a point where we say that, not every form of expression is worth defending? And then we end up in a position of having to decide how to draw those lines and who gets to draw them. And I'm still more of a classic liberal and classic libertarian in that way. I don't want the state drawing them. But when I see something like this, I think, yeah, maybe we do,
Why wouldn't a family want this to be the messaging reaching their children if they're unable to get them directly after the school day ends, as opposed to the sort of narcissistic materialism that the Satan Club is promoting, critical thinking and science?
Now more than ever, children need the gospel. Children today face an increasingly dangerous and hopeless world. Amen, I say. Unchurched families in every country and even locally in your own community have no legacy of faith to pass on to their children. They do not know the reason for our hope. I don't know that you can have a society without hope. And if you can, I think it's called New York City.
And this is what the Satan Club is countering. This is what they have professed to counter. Wherever the Good News Club exists, the Satanic Temple wants to be there to provide some sort of rational alternative. Right?
So Satan Club, you right now you have a right to be present in the court or in the schools, but don't call me if you need it. If you need representation. From my perspective, I'm going to vote with my heart in this case and vote for a better world. You're not part of it.
So a couple of parting thoughts here before we get off. We have a listener and viewer that sent me a text saying, quote, at the start of the trial, Engoron noted that no parties in the case requested a jury trial and that the law mandated, quote, a bench trial decided by a judge. You have probably noticed or already read that this case has no jury, Engoron said. Neither side asked for one, and in any event, the remedies sought are all equitable in nature, mandating that the trial be a bench trial, one that a judge alone decides. So both sides neglected to.
Well, and I don't know if, again, I haven't read the pleadings carefully enough. He's also saying even if they had, he wouldn't have given them one because the equitable claims are forms of relief that only a judge can give. I'm not sure I agree with that. The civil fraud penalties strike me as jury claims.
Well, yeah, that. But remember, real estate is tied up in all of this as well.
Yeah.
Right. And so the property interests require an equitable remedy through a court. I would say, let's see, there was one other one. I think it was over here on Rumble. Oh, it's me again. I sent Owen a letter on Monday. I hope he is getting his mail.
Well, here's the update on Owen, and it's a comment on the power of the Bureau of Prisons. The Bureau of Prisons is not yet satisfied that I am actually Norm Pattis.
Good God.
And the Bureau of Prisons is not actually yet satisfied that I am Norm Pattis, a lawyer. The Bureau of Prisons is not yet satisfied that I am Norm Pattis, both a person and a lawyer representing Owen Schroyer. So my office has had to send them identification, a copy of my driver's license, front and back, a copy of my bar card for the DC Court of Appeals. And then, of course, they said, you didn't send us the back of the card because there isn't one. And so we're now engaged in day 3 or 4 of negotiations.
Sounds like they really know a good protocol, right?
Yeah,
no, really familiar with what they're asking you about.
We're engaged in day 3, or is it 4, of negotiations with the executive office to determine that I am, in fact, who I say I am. And until I can satisfy them, I can't speak to Owen.
It's insane.
And it is insane. So Owen is entering the 3rd week of solitary confinement at the Oakdale Correctional Institution. I've heard reports online from folks who have said they've tried to send him material. It's been returned. Letters have been returned. They've tried to send him books. Books have been returned. Now, in general, folks, if you're trying to send a prisoner a book, you can't send the book from yourself. The prison will be suspicious that you might have something tucked in the binding or between the pages. So the safer course is usually to have books sent directly from the publisher. I don't know if people are doing that in Owen's case. I sent Owen a letter a while ago. It hasn't been returned yet. So I can only imagine that Owen is sitting in isolation, feeling as though the entire world has forgotten him, and feeling somewhat despondent, perhaps enraged. We're going to try again to make contact with him today. And I'm hoping we do. My prediction is that the Bureau of Prisons will find a way to keep him in solitary for all 60 days. We have been in touch with congressional staff members, and congressional staff members have been reaching out in recent days to learn more about Owen and other J6 defendants. So I would say to all of you, continue to write Owen, reach out to your congressman. Ask people when freedom of expression became a crime in the United States, and ask whether anybody really has effective oversight over the Bureau of Prisons. Are we really going to permit it to become an independent sovereign within the United States, a penal colony unto itself? You know, I attended a week or so ago an oversight committee hearing of the Bureau of Prisons by a subcommittee of the House Judiciary Committee, and Representative Andy Biggs of Arizona in particular was asking for permission for a site visit, and the director of the Bureau of Prisons wouldn't give him a straight answer. How does that happen? She had the audacity to come in and say our census is low, but we need money. We need money to hire more guards. We need money to do more improvements. And when the Congress said we want to come and visit, well, I'm not sure I can guarantee that, Congressman. Well, at some point, Congress has to just say with its power of the purse, if we can't go, you get no dough. How about that? You know, I mean, when are we going to have Congress stand up and exercise the power of the purse? It's the only real power we have. Use it as to the Bureau of Prisons. Use it as to the Justice Department. When Jack Smith next comes in, or one of his subalterns comes in with that jalapeno swallowing look, and asks for money, say, no, we don't like the way you're spending what we give you. Get a real job, Einstein.
Well, we will post the Owen Schroyer Legal Defense Fund on X. Follow us on X at LawPod Daily. We'll continue sharing that, Norm. And please do let us know. You can send us an email, pattispodcast@gmail.com. Okay, yeah, I see you. Michigan versus everyone. I see you.
Go Blue.
Send us an email to pattispodcast@gmail.com if you do indeed send Owen a letter and it gets returned. Make sure that Norm is getting as much information from the field on this stuff as possible.
And by the way, we have begun to get reports of people who run into what appear to be illegal immigrants in their communities. And Mike, remind me tomorrow, we can talk about that when we've got time.
Yes, sir. Okay. Everybody, you can find us on X at LawPod Daily. We stream live on X every single day. I love that platform to the detriment of Rumble and YouTube. But I love Rumble because it's where most of you talk to us from. So thank you to everyone that joins us live from wherever you're coming to us from. If you're unable to join us live, you can always catch us on Apple Podcasts, Google Play, Spotify, Overcast, Audible, wherever premium podcasts are found. We do appreciate you. Norm, we got one more this week. We'll see you in the morning.
Ciao.
Bye.